Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at an important book on the law of contract, which I think will be of relevance to a very large number of people. It's called Implied Terms in English Contract Law, now in a second edition, and it's been written by Richard Austen-Baker. It comes from Edward Elgar Publishing, and it's part of the Elgar Commercial Law and Practice series. Now, the book's available as a book, as an ebook, and also online, and I think it's a first-class statement for those who do have some concerns about how implied terms are viewed, and also I think it's useful from the practical point of view as well. Now, Elizabeth and I have given the review title for this review the following: highly useful for all contract law practitioners and those looking for a first-class honours degree in law. And I threw that in for one reason, and that is that if you are looking for just that extra something for your law degree, this is the sort of book where you will find the extra information you're looking for. Now let's have a look at the book first of all. It's from Elgar, as I said. It's a hardback. There's the front, and then there's the spine, and then you can see there's quite a lot of information on the back. It's not a very big book, I hasten to add. It runs to a total of about 182 pages, in fact, so it's not a big book really at all. The index is not particularly large either, but it does satisfy the requirements. A lot of judges are named in this book, mainly because it's to a certain extent about the law of contract and its relationship with precedent. There's a useful bibliography also right at the back, not a particularly big one, which starts there. And then if we go to the front of the book, you've then got the main front section there. You've also got a little bit about the Elgar Commercial Law and Practice series, and then after that you've got some detail there, and a very nice dedication to Jill Poole. Now, it may be that some of you remember Jill Poole. She was a very substantial leading figure in academic law, specifically the law of contract, and her books were very, very helpful, certainly to me when I was studying some many years ago, and actually teaching as well. There's the contents section. Then there's an extended table of contents to develop. There are actually 7 chapters in total, and then there's a preface. That's actually to the first edition, and then there's a very short preface to the second. There's nothing much added, except he's updated quite a few bits and pieces. There's obviously a substantial amount of case law listed. Then you've got some statutes and statutory instruments. Then we get into the book itself. Now, what you've got is you've got a chapter, and then you've got a little index. Then you've got footnotes, of course, and paragraph numbering at the side. Remember that the index is actually, looking at it, the index is by paragraph numbering and not page numbering, in case you're looking for anything. Just opening it in the middle, you can see a lot of subheads, and of course the standard paragraph numbering and the actual footnoting. So, what do I say about this book? Well, this book can be rightly considered one of the leading authoritative accounts of contract law and this particular area in England and Wales, specifically in relation to implied terms, to go with what is the fundamental statement of law contained in Chitty on contracts, which is the cornerstone of the system, and it's where the law is found, and it's also, of course, part of the Sweet and Maxwell Common Law Library, although this is a publication from Elgar, who specialise in high-quality, high-end academic statements on law and business. And we're very grateful to them for the work that they give us, because it does help our lives a lot. Now, implied terms arise frequently as issues of great importance during litigation itself, and I'm sure many of you in practice will have come across it as I have. And as the writer says in his original preface, quote, "A thorough knowledge by the practitioner of what terms are and are not likely to be implied will permit him or her to advise a client what is likely to happen if anything goes wrong in the absence of an express clause providing for that event. Very important statement, I think, and that in essence is the beauty of what this book contains. And it will also be of great assistance to businesses, in my view, when planning and devising effective contracts by giving them the ability to identify issues over which they do not need to negotiate because they would be content with the terms the law would imply. And we think this is another important reason to be aware of the book if your practice requires excuse me, a detailed understanding of how implied terms actually work in the law of contract. And as the author comments, there are distinct commercial advantages to this approach, and Austen-Baker's title includes what he calls savings of management time in negotiating and avoiding trade-off costs demanded by counterparties in exchange for agreeing an express term. And he goes on to say that implication of terms is one of the most important weapons in the armoury of lawyerly and judicial technique, which gives this book such a value, great value, to the legal world. Now, Richard Austen-Baker's second edition, which had come out in 2017, has been wholly revised and updated to cover recent developments in the law. And he covers the following areas in some detail, and I'm going to give you a list of them, which are set out, of course, in the book. There's a full analytical treatment of featured cases and an evaluation of recent case law authorities concerning use of implied terms. Then there's an analysis of major revisions to statutory implied terms brought by the Consumer Rights Act 2015, which of course is the leading piece of legislation. There's a useful synoptic table illustrating how these, or series of tables actually, illustrating how these changes map across the different categories within the Consumer Rights Act and between the Consumer Rights Act and pre-existing legislation. There's a full discussion of statutory implied terms in service contracts of use to business and a detailed examination of some recent decisions. That's from the Judicial Committee of the Privy Council in the Attorney General for Belize and Belize Telecom, and then the leading authority which has been established by the Supreme Court recently in the case of BNB Paribas and Marks and Spencer, which of course most people will be well aware of. Let me conclude by saying we feel that implied terms in English contract law is an invaluable resource for all legal practitioners, both in practice and in-house, involved in contract drafting and contract negotiations. And I think it also acts as a helpful reference for scholars and students in the field of contract law, because it's a very narrow area, but one that we actually come up with in practice quite often. And the law is stated as at 2017, and as I say, it's available as a book, it's available online, and as an ebook. And let me just show you the book once again. Front cover, let's say, not a very big book, and very easy to read. I thought it was quite easy to read. One of the problems with some of the older editions, for instance, of Chitty, is they weren't the easiest book to read. But the English has been modernised tremendously, and I think that helps a lot. Here we go. This is chapter 3, Terms Implied at Common Law, General Principles. You see the structure there. Again, you've got the paragraph numbering and you've got footnoting. The footnoting is really to give you the detail of the cases themselves, and there are some useful quotes from the judiciary. That one is from Lord Cross of Chelsea and a leading authority. Then, of course, going over, you've got a test for terms to be implied in law, for instance. So you've got quite a large amount, as I say, in your own armoury, if you like, depending on what you're needing to advise your client on. I'd like to thank Elgar very much for producing this book, and of course Richard for doing the new edition. It's very useful for us to have this, so thank you all very much indeed. Do have a look at our review, which is on the web and in the journals. Bye-bye.